Well, good morning, everyone. Senator Abart's running a few minutes late, so I'm going to open up the Energy and Natural Resources Committee hearings for today. And not seeing anyone from the House, I'm going to ask Senator Waters to please introduce House Bill 1140.
Thank you, Mr. Chairman. Senator David Waters, District 4, to introduce House Bill 1140, enabling certain disabled persons to hunt from a motor vehicle. This makes some minor wording changes from is suffering from to has paraplegia, has lost one or both or extremities, and then it adds the phrase or has lost the use of one or both lower extremities. So those are the small changes that are made to let some folks hunt who might not otherwise have been able to. Thank you, Mr. Chairman.
Thank you, Senator. Melissa, from New Hampshire Fish and Game.
Good morning, Mr. Chairman, members of the committee. Again, for the record, Melissa Nemeth, legal and legislative liaison for the Fish and Game Department. And we come in support of this bill. As the statute currently stands, only someone who has lost both lower extremities or the loss of use of both lower extremities can hunt from a motor vehicle. And this bill was brought by the prime sponsor on behalf of a constituent who had lost the use of only one of his lower extremities and wouldn't qualify for this permit, but clearly had some legitimate mobility issues that would make it too difficult for him to navigate in the woods. And so we support this bill because it still keeps the intent of having only folks with significant mobility issues being able to hunt from a motor vehicle, and doesn't broaden that pool of people too wide as to who can hunt from a motor vehicle, but doesn't prohibit those that have those mobility issues from being able to take advantage of still being able to do the things they like to do.
Thank you. I guess for my clarification, when line 3, it says has lost one or both lower extremities, does that mean a complete loss or a partial loss would qualify if you had a below the knee amputation?
I don't, that's a good question, and that's in the current statute as the both lower extremities was in there already, and it's having the loss, but then if you read on to 4, or has lost the use of one or more, so it could be either or. It could be they did have an amputation, or they didn't have the amputation, but they cannot use that extremity.
Okay. No, fair enough. I just kind of was reading it and I was wondering exactly how that would be. I guess that would be determined by who determines that has lost the use. Is that a doctor's note?
I believe so.
I was trying to read
And
it.
it comes to the executive director, and the bill as introduced would have actually provided the executive director with wide discretion to determine that, and it was deemed that was too wide of discretion. So in working with the sponsor, we came to this amendment that came out of the House that makes it like, yeah, there is, if you read, that's on lines 11 and 12, that there's documentary proof of the disability. That they have to provide that. So it's not the executive director making that determination. It's utilizing medical information that the applicant provides.
Thank you for the clarification. Any questions? All right, seeing none. Thank you.
Thank you.
Anybody else that would like to testify on House Bill 1140? All right, seeing none, I will close the hearing. What time's our next one? 11:10?
Yeah.
David, you comfortable with it? We can exec it.
I think, yeah. To the starting time. Oh, is that?
Yeah, you want to
Oh,
exec?
yeah. I'll move with that.
I'll second. All in favor? Aye. I'll move on to pass on House Bill 1140.
Second.
Any discussion?
Yeah, if I may, your question about.
Turn your mic on, please.
And your question about lower extremities. Lower extremities are everything from the hip down through the toes, from down through the ankle. But it can be any one part of that. So if somebody loses a foot or from the knee down, that, it all counts. But it's a question of mobility. If you don't have one of those,
Yes.
you're not mobile.
We are in exec session on this first bill. If you would like to vote, you're welcome to. I realize you didn't hear the hearing, and if you would like not to, I'm okay with that too.
Why don't I pass? If you need my vote, I'd be happy to.
I think Senator and Waters and I are in agreement on this, but I'll leave it to you and what your comfort level is.
Why don't you move ahead?
Okay. All right. Seeing no further discussion, All in favor?
Aye.
Any opposed? Any objection to consent?
Nope.
Seeing none, and I will take it out. And with that, I'll take a motion to come out of exec.
So moved.
All in
Second.
favor?
Aye.
We will be in recess until 9:10.
How you doing, Mark?
Morning, David. Very good.
All right, all right.
David.
Nope.
All right, being 9:10, we're going to open the hearing on House Bill 1141, and I will recognize Representative Aaron to introduce. Good morning, welcome.
Thank you. Good morning. And for the record, I'm Representative Judy Aaron. I represent Sullivan County District 4, which are the towns of Ackworth, Goshen, Langdon, Leominster, and Washington. and thank you for having me this morning. I'm here today to introduce HB 1141 to you relative to permitting and fee authority for mining and prospecting. This bill came about after, or at least the amendment to the original bill, came about after an unfortunate incident in my town of Ackworth. A mining business purchased a property in my town which had already had a mining permit, and they wished to continue mining and had to apply for a new permit or a replacement permit to do so. It was a horrible experience for them, which took a couple of years and about $40,000 in fees until it was completed this past fall. The current application process is really unacceptable, and we need to change it as soon as possible. The main problem was that the Department of Natural and Cultural Resources were the ones that were handling the permits, or at least, part of the permits. And they didn't have the knowledge or staff to accomplish the mining permitting process currently existing in statute. Part of the problem was that the statute was from the 1800s. Legal department had trouble interpreting what they needed from the applicants, and it was really a cumbersome and difficult experience. And so they were unsure of what they needed from the applicant, and it caused a lot of grief back and forth. Anyway, the statutes being old and outdated from the 1800s, DNCR legal department, again, had trouble figuring out how the current law should be followed or applied, causing a lot of confusion when dealing with the applicant. And DES has far more experience in permitting, in the permitting process, and they deal a lot with alteration of terrain and other permits having to do with land use. So long story short, after I discussed the issue with DNCR and DES to help facilitate the permit for my constituent, it was felt that DES should be the permitting agency and that the statute should be made clear. DES and DNCR collaborated and came up with the language before you today. This will streamline the process and make it so the next mining applicants don't have to go through a painful and very expensive process in order to obtain a permit. So I ask you please to pass this bill that came to my committee so that we can fix these mining permitting. It didn't come to my committee. It went to Natural Resources. So we can fix these mining permitting statutes as soon as possible. And if you have any technical questions regarding the language contained in HB 1141, I would ask that you direct them to DNCR Commissioner Adam Crapow or someone from his office, or you can also contact Commissioner Scott from DES, and I'm sure folks from DES and DNCR are here that they can answer any of the technical questions having to do with it. But so I appreciate you considering this bill, and I hope that you'll pass it.
Thank you, Representative, for your testimony. Any questions from the committee? Senator Waters.
Thank you, Representative. And, this is not a technical question.
Okay, good.
But on page 3, down lines 22, 23.
Which page?
Page 3?
Page 3.
Yeah, 31 to 33.
Yeah.
So this is the part where you strike the consultation with the commissioner of the Department of Natural and Coastal Resources. So, I served on the Historic Resources Committee for many years before I came into the House. And, I'm just wondering what you thought about that role in terms of consultation, because there may in fact be historical or cultural resources on the site that is going to be mined or prospected.
Well, that was something, again, that when DES sat down with DNCR folks to collaborate to come up with that language, they felt that that was acceptable and reasonable and would streamline the process. I don't really suspect that, there would be mining permitting going on if there was some sort of historical thing nearby or in that area.
Well, that's them.
Yeah.
Senator Pearl? Senator McConkey. Thank you, Mr. Chairman. Representative, thanks for taking my question. Nice to see you here.
Sure.
Curiosity, what are these people mining? I'm not privy to too many operations.
They had, it's like a rock quarry.
Okay,
So they took over a mine in Ackworth, which was producing a lot of stone and crushed stone and that kind of thing for our highway departments and local highway departments. So there's a lot of granite crushing and things like that going on. And the permit that they had was a conditional permit, temporary permit, that they were only allowed to take materials from the site that had already been mined out. And now they've got a full permit and they're able to do what they need to
thank
do.
you. I was hoping for emeralds or
Oh,
diamonds.
gosh, no.
Thanks.
But we do have in Ackworth, we do have the old barrel mines, which were pretty well used during World War II. And then it is a historical site of some degree. And so, yeah, there are certainly some places, I don't know about emeralds. I think you'd have to go to South America for that.
Further questions?
No, thank you.
Seeing none, thank you very much.
Appreciate it. Thank you. And here I have copies of my
Attorney
testimony.
Head?
Morning.
Good morning.
Good morning, Mr. Chairman, members of the committee. My name is Richard Head. I'm with the Department of Environmental Services Legal Unit. We did participate in the drafting of this bill and support it. Essentially, the overall purpose of it is to create efficiencies where currently we have two departments, both of which are involved in permitting essentially frequently, at least the same regulated activity. What we're proposing to do is to incorporate all of the mining that is currently being handled by DNCR into the alteration of terrain program, which already regulates any mining activity that is over 100,000 square feet. So at the same time somebody is applying for a permit with DNCR, they're also still coming to the Department of Environmental Services alteration of terrain unit when that does in fact exceed 100,000 square feet. This would increase the number of files that would be before the alteration of terrain program for those that are less than 100,000 square feet. But it's already a program that is designed and built for this type of regulatory purpose. So the efficiency, both in having only one permit place to have to go to, and also being managed by a body that's already heavily invested into the regulatory and permit processing, or was involved in the permit processing anyway. I did want to briefly walk through the bill just to sort of identify what it's doing or why it's doing it, and then answer any questions. And it's actually a fairly simple bill in the grand scheme of things because the regulatory framework already exists within the statute for alteration of terrain. All we're doing, starting on page 1, line 1, is adding to the definitions of what's covered those things that are currently covered within the DNCR program. So sections 1 on line 1 and 2 on line 8 are simply definitional provisions that bring it into the Department of Environmental Services. Line 19 on page 1 pulls in from existing exemptions in RSA 12E into the alteration of terrain definitions. Page 1, line 25 is again going back to the definitions. It's done in 4 different parts just so we didn't have to reprint all of the definitions in the statute. We just pulled in the new ones. Page 2, line 6 brings in the financial assurance requirements from RSA 12E and brings it into the alteration of terrain program. Page 2, line 11 is the provision that brings in the regulatory or the rulemaking authority for the alteration of terrain program to cover any new activities that are being covered by this move into from DNCR to DES. It also, just to highlight and flag it for you, in section 6, page 2, line 33, there is a fee change that's actually not related to this mining bill. It's in here to correct a gap that was created in last year's legislative session when the alteration of terrain permitting program was modified to create a permit by notification for projects that are between 100 and 150,000 square feet. And it changed the fee for that. The problem that we've noticed since then is that there are a small number of applications between 100 and 150,000 square feet that still need a full application, primarily those that are being done within a protected shoreline. So those applications under the fee structure that passed last year were getting a maximum of about $1,000 when the reality is it's a fairly technical review with the full application, and we wanted to build in the application fee that recognized the review that was being done for the very small number of applications between 100 and 150,000 square feet that actually need under the law a full review.
So this is a fee reduction.
It actually is. It's a fee reduction, but for some applications. On the lower end, on the lower end size between 100 and 150, it's a reduction. As you build up the number of square feet, about halfway through that, it actually ticks it up a little bit, so it recognizes sort of the total work that's involved. So it actually is a reduction in terms of the numbers, but because of the change over to being able to calculate it with the flat fee, it actually, as you go up in size, it's an increase.
Let's get there.
And I'm a lawyer, so that's as close to math as I'll get today. The next section is page 3, line 3. These are the fees that are in fact related to this transition. And basically puts into rulemaking to ensure that the department can cover its additional costs associated with essentially those permit applications that'll be new to the alteration of terrain program, to make sure that we're able to recover the fees for that. One thing it doesn't do, because we're a regulatory agency, is it does not provide income to the state as it relates to essentially minerals that are being extracted. Whether as a policy matter in the budget cycle next year, you want to consider doing that as a income generating process is up to you. It is not currently in 12E. We did not incorporate that into this law, but I did want to just flag that the fees here that are designed in this bill are simply to cover the additional cost that the department would incur as a result of this transfer to the department. Page 3, line 26, as Senator noted in his question, would eliminate the reference to DNCR as it relates to the state geologist. And actually the reason for that is because the permitting is currently with DNCR. DNCR is supposed to coordinate with the state geologist who is in the Department of Environmental Services already, so that consultation happens as a matter of course. As it relates to the cultural resources aspect, that's already built into the alteration of terrain program permitting process. If there is a cultural issue, I think it would get flagged there.
Question?
But
Yeah, I mean, just while you're on that, so you're referencing probably the rulemaking around that?
that's correct.
All right, so, because I looked in, was it 485A17, there's no particular reference to it, but what I'm concerned about in the rulemaking, that obviously we need to cover historic burying grounds, and we need to cover archaeological resources, particularly Native American. I mean, that's in statute otherwise, those
Sure.
areas, so that's, the assurances under the rulemaking here it would be clear that for those and other potential historical resources, that review would include that as required.
And I appreciate it, and thank you for the question, Senator. If you wanted to be explicit within this bill, we could incorporate that in as a requirement of the rulemaking process. It would actually go up into the rulemaking section. This here is simply a reference within 21O as to the state geologist who's not doing the permitting in this. But if you wanted the explicit requirement that the application or that the
If you don't mind, because, I remember we had a case where the historic, the abandoned colonial village that just is the series of historical cellar holes and other sites over near Chesterfield somewhere, but anyways, that there are some important sites. And so if you could provide us just with a phrase for an amendment, depending on if the chair's comfortable with that. I think we got to do what the bill does. But I just would like some assurance in statute that the rulemaking would incorporate consultation with cultural resources, particularly on, historic burying grounds, archaeological sites, Native American and other relevant sites.
And I think if it makes sense to you, I'd just incorporate explicitly within the rulemaking section that the applicant, prior to filing with the department, consult with cultural resources to ensure there are no adverse impacts.
Yeah, and if I may, and I think that from my experience with that department in my years on the board, that review process, it's like the section 106, it's very quick. So,
I understand, sure, and it's done, I understand, and certainly can add that explicit reference within the rulemaking authority.
Thank you.
Got that, Joshua? All right. Senator McConkey? Now hit your button.
Thank you, Mr. Chairman. Jake, I'd like to back up as a moment on page 2 when you started on 31 to 36 and possibly further on, talking about projects that involve in the shoreland that are somewhere between of a smaller magnitude, 50,000 to 150,000 square feet. What I'm reading here only relates to projects that are going to be mining or prospecting in that area. It has nothing to do with shoreland applications.
So thank you for the question. What this would apply to is when you get into an alteration of terrain project that's within the protected shoreland, the jurisdiction starts at 50,000 instead of 100,000 and goes up from there. What in last year's session, and again, this particular fee is unrelated to the mining part of this bill. It is simply to fix a loophole that was created with the permit by notification process, that because a alteration of terrain permit that is within the protected shoreland is not a permit by notification, the permit by notification fee, which is obviously substantially reduced from a normal application, was not covering essentially the costs that the department was incurring in reviewing the full application. So what this fee does is simply corrects that loophole for a project that is between 50,000 and 150,000, where there is a full application that my apologies, let me take that back. So for any property subject to 483B9, which is, I don't have it in front of me, I think it's the permit by notification section. This simply allows for those projects to be the fee structure to cover the costs that the department incurs as a result of the full application that would come in those small subset of applications where the alteration of terrain activity is within the shoreland.
If I could, because I'm more confused. That happens. So
It happens to me, I apologize.
This written into this section, which is referring to permitting authority for mining and prospecting. And we're speaking of AOT permits, which I understand we're switching who has the authority of these projects or permitting. But this language, 31 to 36, is only relevant to AOT permitting that is relevant to this legislation, or is it to all AOT in that size?
All AOT in that size, yes, all AOTs in that size. So,
Seems an unusual place to slip that in. Maybe someone can explain that too.
you know, it was simply because the subject matter related to AOT. The reality is, if the Senate wants to pull that out, it doesn't change the overall project or change that we're making here. So if that particular fee change is of concern to this committee, it can come out without affecting the rest of the bill.
Okay, one last thing, if I could, Mr. Chairman. So when you said it's, the category was just made last year, and I believe gentleman sitting in the audience was one of the people that made that work happen. And you said it's used on a limited basis. Can you tell me how limited that has been?
Oh, thank you for the question. I do not know myself how many applications came in that are within this category of 50 to 150,000 that would not be permit by notification. As compared to those that are permit by notification, I don't have that number. I can get it for you.
Have you indulged me one more time, Mr. Chairman? So the application fee was $500, reduced to $250. And then from 5 cents per square foot to 4 cents per square foot. Am I reading that correctly?
You are, that 0.005 to 0.04.
Yeah. All right. Thank you so much. Thank you for your indulgence.
I have a question. Senator Pearl. Thank you. Good to see you again.
Thank you.
I believe I'm okay on this, but I want to just make a clarification. This isn't in any way going to affect someone who's doing, say, a land reclamation, putting a woodland back into an agricultural field, or perhaps a flood restoration where there may be material that needs to be moved. I don't believe this would apply to that. Would you agree with that?
I would. And that's through the definitional changes. What we are adding is the extraction of dimensional stone and mining of minerals, and then minerals is further defined as copper, gold, silver, so on, et cetera. So it's that activity related to mining and prospecting of those materials, not, as you said, the reclamation process.
Yeah, I was thinking more of the flood restoration process sometimes, because there sometimes are offsite materials that are brought onto a field that need to be removed.
No, if there is a disturbance of greater than 100,000 square feet, or if it's a shoreline 50,000, if it's normal alteration of terrain activity, that may fall within the existing program. But as it relates to what this bill is doing, it's strictly related to the mining or prospecting activity.
And so that activity wouldn't be considered mining.
Correct.
Okay, thank you. Any further questions from the committee? Lost you over there, David. All set? All right, thank you.
Thank you.
Commissioner. I don't know if that's permanent yet, but acting.
I don't know if it will be. Good morning. Members of the committee, for the record, I'm Adam Crapo. I'm the interim commissioner at DNCR, and I have with me Nate Kennison Marvin. He's our attorney at DNCR. I'll be brief. I think Richard really did a great job outlining what this bill does. But what I would say is this is sort of a long time coming. This is a conversation that started well before, I would believe, back to 2020 or 2021, and it sort of was a back burner project that both agencies had been looking at but hadn't really initiated. And then we at DNCR we did see a slightly higher volume of mining permits coming in, and what precipitated from that was the realization that we didn't have rules in place at the time when these mining permits were coming in, and we only had a staff of one until we hired an attorney, and then we had a staff of two looking at these, which are very complicated, complex applications for mining within the state of New Hampshire. And so when while I was at DES, the former commissioner had reached out and said, hey, is this something that you'd be interested in taking on? And so we looked at it and we realized that if you looked at a Venn diagram of the overlap, it's about 90 or so % of overlap of what both agencies look at. The remainder, which is in DNCR's court, is really the financial assurance pieces. And a lot of what the staff at DNCR do already is consult with the staff at DES for their expertise on mining generally and with the state geologist who was a DES employee. And so, that's what kind of precipitated this. And so we put this together. I will say, and I know Senator Waters isn't here, but historic reviews for burial grounds and I think what he was getting at is not currently part of the review. It's not statutorily required as part of the mining permit application process currently. So we did not put it into the new process at DES because we didn't want to add an additional layer of review that wasn't already there. And so I wanted to make that point. The other thing, and I wanted to sort of touch on the alteration of terrain question, that was in addition because last year when we put that permit by notification into place, we noticed that we created a loophole where folks who were not seeking a permit by notification, but were not seeking a full permit, as I understand it, sort of fell into this loophole where they were significantly underpaying for what they were receiving in service. And so what the intent of that was to right size that loophole. It's a handful of applications. If I recall, we can get you the number, Senator. But that's what that was intended to do, was sort of right size that for the level of effort that the staff at DES were putting in to those specific applications. And so there's no intention to impact what we accomplished last session. We still believe that was a great addition to the permitting process. And then I think with that, I would say, DES has the technical expertise to do this permitting work for mining. DNCR currently, unless we hire more people to do it, currently does not have the expertise or the ability to do this in a timely fashion. We can certainly do it, but one of the reasons why some of these mining permits were taking the time they took was because of the resource constraints on the department. And so as part of sort of the broader permitting, looking at permitting generally in the state, as you may recall, we did transfer some permitting from DNCR and Fish and Game to DES. This was another look at that to see, okay, how can we make it easier for applicants to navigate the permitting process while still preserving the environment and our natural resources. So that was sort of the balance that we took when we looked at this. So with that, I don't know, Nate, do you want to add anything to that?
Just for the record, Nathan Kennison Marvin, legal counsel for the department. Good morning, everybody. I think Commissioner Crapo summed it up very well. Representative Aaron had expressed some frustration with the DNCR, and I've been working with DNCR from my prior role at the Department of Justice when those issues came up with respect to the applicant that Representative Aaron was referring to. And I do think in having worked with the department from outside at DOJ and then now internally at the department and seeing the inefficiencies that existed within the current system and the strain on resources within our department and the land use administrator who is effectively running the entire mining program in addition to all her other responsibilities, that it really does make sense to put this in the agency where the expertise lies. Because from my vantage point, I saw that land use administrator frequently having to confer with DES over things that we're charged with within our statutory jurisdiction that were frankly inefficient to lie there. So I echo what Commissioner Crapo said in full.
Senator McConkey?
Thank you, Mr. Chairman. Gentlemen, nice to have you here. Adam, always a pleasure. I want to go back to, and thank you for clearing that up. I'd like to go back to page 2. And this is, you don't have to pull it up. It's just a conversation we're about to have. I like the energy of reducing a fee from $500 to $250 and going down a penny. But the truth of the matter is, we have a hard time funding cyanobacteria funding going forward. There's a task force that we hope will move forward that is going to be pulling your department heads, and you've always been good at this, in finding ways of a sustainable fund going forward. If this legislation were to go forward, you have legal sitting here with you, would it be possible that we could change this so that the fee were to remain the same, but that $100 and that penny would then go, instead of to your department or DES, would go to the cyanobacteria fund, which is already established? It's more of a high-level thought, but would you think that that might be possible? Or could you get back to me?
Certainly anything's possible. What I would say is this.
And I'm only saying it because it could happen this year in this legislation as opposed to coming back in another year. There.
What I would say is the permitting fees right now for these small subset of applications are not currently funding the level of effort that the department puts into these applications. What I would suggest, and we can certainly talk about this, is maybe taking this, if you're not enthusiastic about this fee change, taking it out of the bill, and then maybe kind of having this as a talking point or a discussion point with that committee to see if that's an avenue. Again, these are very few applications. I would venture to get, I'm venturing a guess, I'm not confirming, but my understanding is it's a handful of applications, and it would not generate a significant enough amount of revenue to fund cyanobacteria just from this small set of applications based in here. However, I think we would be open to that discussion relative to AOT permitting fees generally, because AOT permitting is directly related to stormwater infrastructure and infrastructure related to ensuring that we are not contaminating surface water within the state. And so I think that thought process is a good one. It's just, I don't know that this fee increase would do what you're seeking to do there.
Okay.
Follow up?
And thank you, and I appreciate that. But correct me if I'm wrong, the way this is set up right now, it's going to reduce that fee from $500 to $250.
The way this is set up is it would reduce that fee from 500 to 250, but then it's a half a penny right now, and it brings it up to 4 cents as the project scales up. And so for smaller projects, again, this is a really small subset of the larger AOT permits.
I understand that, but at this point, you're giving up $250.
For smaller projects, but for larger projects, what this is doing is.
Oh, I fully understand the larger project. I understand that. My point is incremental over time, contributing many small places is going to build up a fund. And I see that this is the opportunity, and I'll take it away from here, but this is an opportunity that won't rub Ways and Means or anyone else in a wrong way. So I'd like to have that further conversation after this meeting.
Let's have that further conversation. Absolutely.
Thank you.
Further discussion? Seeing none, thank you very much.
Thank you.
Appreciate it. And with that, I don't have anybody else going to speak on this, so we're going to close the hearing on that and open the hearing to 1275. And there should be an amendment. Thank you. And we're going to hear from the prime sponsor. Welcome, prime sponsor. Thank you. Everybody's going to copy that. It's going to be constant, so the DA can continue to make the copies. Okay. Yeah. Whenever you're ready.
Okay. For the record, I am Representative Wendy Thomas. I represent the town of Merrimack.
This is yet another PFAS bill. What it does is there's 3 sections to it. The first section is a civil liability section. The second part that it does is that sludge cannot exceed maximum concentrations. The third part is that the DES shall initiate rulemaking for PFAS standards, and then the date that it shall take effect upon its passage. Now, I've worked very closely with the Conservation Law Foundation and Just Zero, and we're fine with the second section and the third section of this bill. However, the civil liability section is problematic because the civil liability section was originally hooked to a ban, and then it was hooked to a 5-year moratorium. And I'm going to give you the reasons why we would like the civil liability portion removed from this bill. And that's what the amendment that you have, that's what it states. I've never seen an amendment like that before. That's the verbal directions for the amendment. It says remove section 1 and move the other ones up. Anyway, so these reasons for removing the civil liability come from the Just Zero lawyer. The original intent for the bill was to completely ban the practice of spreading sludge, or at least pause it for some time. This amended version will allow the practice to continue, so granting civil immunity is much more risky. It is more likely that bad actors will take advantage of a civil immunity loophole. The civil immunity language was pulled from an early version of a Massachusetts bill on the same issue. We have since learned that there are serious concerns and debate in Massachusetts on that language. In fact, Massachusetts is currently removing that language. Liability exemptions have the unintended consequence of protecting individuals who may have acted negligently or even in bad faith. Any exemptions can open the floodgates for more carve-outs for other industries and even for other pollutants. The likelihood of lawsuits against farmers is extremely low because most farmers, 1, acted in good faith on government direction that this practice was safe, and 2, are not financially viable defendants. Plus, federal law already protects innocent farmers when determining contamination cleanup liability. Now, when we talk about bad actors, what we're talking about are something called sludge farms. And these are plots of land that are purchased to dump sludge, and they're considered farms. I have examples of 6 of them throughout the United States. Some of them are as large as 52,000 acres. That one is in Denver, Colorado. And they're used to just dump the sludge, and they're considered farms. One in particular that you should know about is the Dixon Farm in Steuben County, New York. It has been spreading sludge for decades. Casella took it over in 2022. It consists of 2,663 acres that are used for sludge dumping. Dixon owns it, but Casella now leases it. And so that's the concern, is that if we keep the civil liability portion in here and we don't have a ban or we don't have a moratorium and we have these sludge farms, then we're giving them protection, civil protection, which could be problematic because they're still doing this practice and they get civil protection. So what we're asking for is to remove that civil protection piece because we don't have a ban, we don't have a moratorium, to keep the other 2 pieces in, and then we would be very happy. If you want to keep a civil liability piece in, Representative Germana is going to be introducing an amendment with a limited civil liability piece. But our preference is to remove it completely for now. We're going to meet this summer and we're going to come up with some solutions for further protections for PFAS. And maybe we'll have some kind of civil liability put in for farmers at that point. But for now, we want it removed. We would like it removed.
Senator Waters with a question.
Yeah, so Thank you, Representative. And this is not a topic that is new to us. We in fact had to go to court over application of sludge to some farmlands when we set our standards, and we did get a Supreme Court ruling that we could do that. And we know, particularly in Maine, the extraordinary damage that has been done to farms that were centuries old, which have had to go out of business because of this. So I think we really need some protections here. It seems to me, from your comments, that we've got two amendments that might come before us.
Correct.
And I don't know if either of them has the support of your committee, or is it just that you're bringing it?
I'm not on the,
No, I'm.
so
yeah.
the committee, the people that I'm working with, so I'm working with Just Zero and Conservation Law Foundation. Their preference is to remove the civil liability piece completely. Their second choice is they're okay with limited liability, but their preference is to remove it completely.
Well, I'll wait till the chairman, the chair is up here. Thank you.
Any further questions? Seeing none.
She's coming up. The chair.
I'm going to have Judy next. Yeah.
Thank you.
Representative Aaron?
Why do we want to do that? Well, you can talk to it.
And that concludes the day.
Yep. Okay. Pardon me, sorry. So for the record, my name is Representative Judy Aaron, representing Sullivan County District 4, towns of Ackworth, Goshen, Langdon, Leominster, and Washington. And I'm coming to you this morning as Chair of Environment and Agriculture. We passed this bill out of our committee as is. I think this is a good bill because we are, first of all, we want to have the department, DES, come up with rulemaking to develop the standards. We have no standards right now regarding PFAS and biosolids for land application sites. And I want to say we're not Maine. We don't have the same problem Maine had. And we also don't have that much land in New Hampshire that is receiving biosolids. That was testimony in my committee. I know that there are some amendments that are going to be presented to this committee. I think the bill is fine the way it is, quite honestly. And we're also asking for DES to set those standards for the PFAS compounds for which an ambient groundwater quality standard has been established. All that's in the bill here. We think that makes a lot of sense. You can't really make bans or limitations unless you know what you're dealing with to begin with. And we don't know what is currently on some of our farmlands, or what has been spread, or what the levels of concentrations are. And so we want to take a look at all of that first before we make any kind of legislation banning anything or restricting anything. The other part with the civil immunity, we had discussed in our committee about, we want to encourage farmers to test their land if they've used biosolids, or if there have been biosolids put on their land before they purchase their land, so that they can at least find out. And they should have some sort of immunity from civil liability. If they don't know what's on their land to begin with, why should they be punished for something that maybe they're not even responsible for doing? I think, you have to set a time for what we're doing and going forward, as opposed to punishing people for something that's happened in the past that they couldn't control or that they didn't know about. So I think this bill, the way it is, we are not placing any restrictions on anything yet until we find out what we're dealing with. And that's all I really wanted to say about this bill.
So thank you for your testimony, Representative. So there's a place, I believe it's between exit 17 and 19. It's not the sod farm, but it's near the sod farm. And for years, they were dumping sledge in that big field. Now, I believe they've stopped, but it seems to me that if anybody's purchased that and didn't know about it, they would be on the hook for,
Yeah.
right?
Right. And, the other thing is too that we heard from companies that create or produce the biosolids, and they do a lot of testing, and they have certain standards which they have to follow. So again, we're not Maine. Maine was spreading all kinds of stuff everywhere and causing all kinds of problems and pretty much poisoning their land. I don't really believe that that's in any way, shape, or form near what we have here in New Hampshire. But I think, it's prudent for DES at least to come up with the standards by which we should move forward with and apply that.
Senator Waters.
Thank you. So if a company that's providing these provides ones that violate the standards that we have in New Hampshire, they would be liable for penalties.
I believe that would be true. If it's not, it should be. I mean, but they have some standards that they're following when they're creating the biosolids, and they do all the testing. But again, we don't know what's already been placed on certain properties or what the cumulative effect, if any, there is. And that's kind of what DES needs to establish.
Thanks for me follow up.
Follow-up?
Yeah, and we don't know until we know with PFAS. And I know, in Dover for many years, it's biosolids from the wastewater treatment plant are being spread on fields on Dover Point, and then you could go and load up your car and put it in your gardens. And so we don't know what we don't know until we know it when it comes to PFAS. So thank goodness we're not Maine. But you're comfortable with this version
I am.
here going forward. Thank you.
Any further questions?
I think she answered my question.
Okay. Thank you, Representative.
Okay, thank you.
Allison Jumper. Yeah. I'll take that, yeah. Do a quickie.
Hi, good morning, Chair Avard, Vice Chair Pearl, and honorable members of the Committee on Energy and Natural Resources. My name is Allison Jumper. I'm from Durham. Thank you for the opportunity to support and testify on the amendment put forward by Representative Wendy Thomas this morning on House Bill 1275. 5.5 years ago, my family discovered we'd all been exposed to very high levels of PFAS. PFAS had found its way into our family's farm-raised beef directly from feed grown on our family's fields that had been contaminated with PFAS by land-applied sewage sludge. We ate this meat sporadically for only 4 years. That's all it took for all 5 of us to have levels above the 95th percentile of PFOS, PFNA, and PFDA in our blood. My 3 children ate this toxic meat starting at ages 2, 4, and 6, and continued to do so during critical developmental years of their childhoods. PFAS have been linked to developmental disruption in children, in addition to many negative health impacts, including various cancers. New Hampshire has allowed sewage sludge to be land applied for decades and continues to do so. New Hampshire does not currently regulate PFAS and sewage sludge bound for land application. When HB 1275 was introduced, I supported it as it was written at that time. When it was introduced, it included a moratorium on the land application of sewage sludge here in New Hampshire. It also included a farmer relief fund so that farmers would be able to access financial relief during the crisis that is discovering PFAS on farmland. I still very much support a farmer relief fund and a moratorium on the land application of sludge. Please do support Representative Wendy Thomas's amendment to eliminate civil immunity language in this bill. It just does not make sense to provide civil immunity while the state continues to land apply PFAS-laden sludge. My support of HB 1275 overall is contingent on removing that civil immunity language. I also, lastly, just want to ask that any standards that are developed by New Hampshire DES to regulate PFAS and sludge going forward are developed so that they protect the health of the people in New Hampshire. There is no safe exposure level for PFAS for people. We know this. Standards really do need to recognize this very simple and proven fact. The future generations here in New Hampshire really deserve a PFAS-free future. So, thank you.
Thank you. Questions from the committee? Seeing none, thank you for your testimony. Representative Bixby.
I'd like to have Representative Germano go first since he has the amendment that was referred to earlier.
Okay. Yep, I know, I just gotta get the reps out of it. Yep.
Thank you, Mr. Chair, members of the committee. For the record, I'm Nick Germana, representing Cheshire District 15. When this bill was brought to our committee, we saw the value in it, the importance of the issue. We had a lot of really productive hearings around it. We're all well aware of the tragic history and you get a legacy of the application of PFAS-laden materials in Maine and the consequences there for their farming community and public health. And so we thought it was important to bring you all a bill that, as Senator Waters pointed out earlier, we don't know what we don't know, right? So what we need to do is establish a baseline understanding of what we are looking at here in New Hampshire. We are clearly not Maine, but we do also know that PFAS is found in some of the remotest places in the world. There's PFAS found in the Arctic. It is present in the atmosphere, and it ends up on land through precipitation, right? So we're not in that situation, but we need to know where we are. And that's what this bill does. The parts of the bill, Roman numerals 1 and 2, as Representative Thomas pointed out, what this does is it says that the application of biosolids will not exceed certain limits. DES will determine what those limits are. They are currently carrying out investigations to help them understand how PFAS in topsoil kind of filters down through and reaches certain levels in groundwater. They're doing that this year. They expect that work to be done hopefully by around October. What this bill would do is have them begin rule writing to use that information to determine what levels are appropriate. The question about civil immunity, we think it's important to make sure that farmers who have been engaging in agricultural practices that have been legal are not put in a situation where, in a legally untenable situation as a result of practices that, were not about malfeasance. So there is the civil immunity piece that is in the bill you have in front of you. What I have provided is an amendment that narrows that simply to make sure it is strictly for agriculture, right? So there are two reasons why I think narrowing this is important. Number one, as Representative Thomas has pointed out, there are places in the country where solid waste companies, because solid waste companies, as you all know from dealing with this issue, end up with a lot of this sludge. Only a fraction of it ends up being spread on agricultural land. An enormous amount of it ends up in landfills. So there are cases around the country where solid waste companies buy land, it's determined to be agricultural land, and they use it simply to dump sludge. That would not be protected under the amendment that I have provided you. It probably would be protected if we don't narrow it. The other piece is to make sure that going forward, right, there's no sunset on this immunity. Going forward, if anybody knowingly violates the rules, they should not have civil immunity for doing that, right? That obviously is not a good faith agricultural practice. So I think that narrowing it makes it specific to farmers. I shared the amendment with the gentleman from DES, who I think will be testifying. They looked at it, they can speak to it. They said that the amendment makes sense to them. So the amendment that I provided, as I said, is to make sure that we are providing the appropriate immunity for farmers, but we are not accidentally opening up immunity for people who should not be getting it.
Questions from the committee? Well, good job.
All right, thank you.
Representative Bixby.
Good morning. Thank you, Chairman. I'm Representative Peter Bixby, Dover, New Hampshire, Stratford, District 13. This bill is specifically about PFAS in agriculture. One of the things that I'm sure you're aware of is that PFAS is a real problem. It has serious health issues. That's been mentioned by some other people who've testified. I'm not going to go into that further. This bill is a follow-on to one we passed in the 2023-24 session, asking DES to make agricultural soil maximum concentration levels for PFAS after the USGS background level survey was complete. That background level was completed, I believe, last year, and what it showed was that there are even in places where there is no evidence of any sort of source, like spraying or spreading a sludge or any other known mechanism for PFAS deposition. Even in those areas, there are background soil level levels of PFAS that are measurable, and so that there's no place that there isn't PFAS at this point, basically. And you can get more details on that from the folks from DES. The recognition that PFAS in agriculture is a problem is relatively recent. There's just this spring, the National Academy of Sciences came out with a report about 150 pages long, summarizing the current state of knowledge of PFAS in agriculture. I went through that. It's pretty technical, so I didn't grasp all of it. I'm certainly not going to try to dump all 150 pages of that on you right now. But one of the key things that is clear from that report is the state of science on this is still very much in progress. One of the things that they pointed out is that at this point, there is very little test data on PFAS in agricultural soils at all. And that comes back to one of the purposes of this bill, which is to require that any place where biosolids are spread be tested, and also to make testing available for farmers who want to test. And we tried to put in some funding for that. We realized it wasn't going to work, but we did put in the civil immunity for farmers who want to test is really critical, because if there's some risk that you're going to discover something on your land that you don't want to know is there, you're going to be more hesitant to test if there's a chance that you will also be sued for the products that you have put out, that you have sold in the past. So that civil immunity is really important in order to encourage the testing. We need more testing to know what the lay of the land is in terms of PFAS in agricultural soils. So at this point, there are no MCLs established by the federal government for PFAS in agricultural soils. There are a few states who have some preliminary levels, but we're actually going to be one of the first states to actually have a rigorous process for figuring out what the levels are what those MCLs should be in agricultural soils. And DES can give you more details on the process, but the basically, they're using the levels in drinking water as a basis for figuring out what should be allowed in soils. And the soils tend to grab onto PFAS, so it doesn't move through the soil. A lot of it gets bound in the soil. It moves through the soil fairly slowly, so the levels that are in the soil are not reflected in the levels in the groundwater. But there's some point at which the level in the soil then results in a certain level in the groundwater, which is higher than we want it to be. And those are the levels they're figuring out. And that's how they're going to be establishing the MCLs. So it's really critical that we establish these MCLs so that we can know, is it safe to apply, is sludge below that MCL level so it would be safe to apply, and are the soils it's going to be applied onto also below that level so it would be safe to be applied. And we want to make sure that we don't end up adding more PFAS to soils that are already compromised. But given that there is a background level of PFAS everywhere, we can't be absolutist about it and say, we can't have any PFAS anywhere, because we lose before we get out the gate. So it's important to have actual levels, and having those levels will allow companies that do spread biosolids to make sure that their product is below the allowable levels and still continue with that spreading. And I know that that's really critical for our waste management the human waste management divisions. I'm blanking the specific term, but the water treatment plants need to be able to, or sewage treatment plants need to be able to have an outlet for this that, if it can be shown to be of a safe level, it would still be able to be spread. That I think there will be other people who are speaking in more detail to that, but part of the point of this bill was to make sure that we did not create a total ban so that those people would be shut out.
Senator Pearl's got a question for you.
Sure.
Thank you, Mr. Chair. Thank you, Representative. I mean, the many years we have served together, we've worked hard on defining what farming is. In 2134A, we've certainly addressed that on many occasions, and I was kind of reviewing that definition as I was sitting and listening to the testimony. I think the concern raised was about having a sludge farm, and just the storage of sludge and no other presence or activity of agriculture. At least from that was my understanding, that was the concern. I think we're pretty clear in our definition of agriculture. Again, I was reviewing it while I was listening, that there has to be, that's sort of an ancillary thing that can occur, the storage of sludge. That just can't be that will not qualify you as farming, so to speak, or the presence of agriculture just in storing sludge. So I guess my question to you is this: in reading both of these definitions, the ones currently on the bill and the suggested amendment, it appears like the amendment moves more toward defining that the immunity is only solely from the presence and not really the application of spreading or anything that's otherwise related. Am I reading this correctly?
Right. So what Representative Germana's amendment does is it makes sure that the immunity is in place for someone who has essentially inherited a situation, either that through no knowledge of their own, and that inheritance could be that they were. Because spreading sludge was legal in the past, they would not have had a reason to suspect that what they were doing was contaminating their land. So if they had allowed the spreading of sludge on their land, or like on hayfields or something, in the past, without knowing that was a hazard, then they would be immune. If they if in the future, after the MCLs are in place, they spread sludge that is not within those limits, then they would not retain that immunity. So
Your follow-up?
does that cover your question?
I think so. I mean, the way I'm reading it is the original bill just provides immunity for the practice of applying it, whereas the amendment applies immunity from it being solely present in the soil or water. I'm just trying to, it narrows it. I'm just trying to understand exactly where we're trying to get and why, what the original issue is with the language. Because
Okay.
from Representative Germana's testimony, and then maybe I misunderstood, I was taking it, well, and I guess Representative Thomas as well, that they were more concerned with it being used as biosolids storage rather than not just for the use on farm, but just as a storage facility.
Right. So the reasoning behind trying to get rid of the immunity entirely is that you're assuming that that the sludge, that the PFAS is there because of bad acting, and the assumption with providing immunity is that there is a very good chance that the PFAS is there not through any sort of intention of the landowner, and Representative Germana's amendment basically kind of takes into account both of those potential problems, which is that we don't want bad actors using that immunity as a way to, going forward, excuse spreading things that should not be spread. But we also want to make sure that that pre-existing PFAS on land is covered by that immunity, because we want our farmers to be able to test their land to make sure that it's clean, or if it's not clean, be able to deal with it, as opposed and not be afraid of doing that because they might get sued because they had sold products in the past that might be contaminated.
One more follow-up.
Okay, we have to speed up because we're going to be getting kicked out at 12 o'clock. So I got
Okay.
some more bills, but if we can ask a question and wrap it up.
Right. So I just want to, I have a couple comments I want to make just briefly after the questions.
Okay, because I am going to be running out of time.
Yeah.
So in either case, the land application, whether it be previous or up until the point where levels are established, the immunity is going to follow the farmer to that point. Once the levels are established, won't that change what the farmer can apply at that point?
It will change what the farmer can apply.
Yeah.
So if the farmer has the bad luck of having contaminated land, then they would not be able to apply more biosolids that had any measurable amount of PFAS in them.
Thank you.
Senator Rosenwald?
Thank you, Mr. Chairman. I guess I'm confused as to why we need to twist ourselves into knots about what happened in the past and what would be the case going forward. And I think I'm following up on Senator Pearl. If this bill passes and becomes law, like every other law, it's not retroactive. So you would only be liable for what happened in the future.
Right. So you would be liable if you violated some aspect of what is in this law. That has to do with that creates a liability in the future. But if you were selling products from your land and they were contaminated, and it becomes known that they were contaminated, then it is conceivable that someone might have a basis for a suit for what you were selling for what you sold in the past, and that's what the liability is protection is here for, so that farmers will not fear having their land tested because they fear that they might get sued for having sold products that were contaminated.
your follow-up? Okay. If you can wrap it up.
Okay, so one point I want to make is that it's clear from the National Academy of Sciences report that there are multiple pathways for getting for PFAS landing on agricultural soils. It's not just biosolids. There basically any input that you have on your farm could potentially bring PFAS with it. And when it's on the farm, it is likely to cycle through on the farm. So it does get taken up by plants. When those plants are eaten by herbivores like cows, then it gets into the meat, it gets into the milk, and it gets into the manure. That manure becomes a cycling source. So those aspects are not being addressed by this bill because we don't have a clear enough understanding of how that process works yet. So the MCLs in this aren't going to reflect that aspect of it. It's going to they're going to reflect our understanding of how the PFAS goes from soil to groundwater.
Thank you, Representative. Appreciate it.
You're welcome.
No further questions. Next we have April Sargent.
Good morning. I'm April Sargent. I'm here representing New Hampshire Water Pollution Control Association as the chair of the Government Affairs Committee. Thank you for having me here. The New Hampshire Water Pollution Control Association is a nonprofit membership organization that represents organization that provides education, workforce training, expertise, and advocacy for New Hampshire's clean water utilities. Our 300 members represent all of the publicly owned water treatment plants in New Hampshire. In general, we're in support of the bill. We commend the House Committee on their work to remove the proposed moratorium because for wastewater treatment facilities, managing their end result of the process, which is the biosolids or untreated wastewater solids, is a big concern, mostly because of outlets and where that material is going to go. In New Hampshire, there's really only 3 outlet opportunities, and that is land application, landfilling, and also incineration. New Hampshire only has 1 biosolids incineration, and that's Manchester, and they only take their own sludge. They don't take outside sludges. We recognize the concern regarding PFAS and its impacts on soil and agriculture and public confidence. And we really like the framework that is now of this bill that's focused on rulemaking and continued land application under defined conditions that protect human health and the environment. This reflects a more balanced science-based approach. I think we've heard others testify that PFAS is widespread society-wide with multiple environmental pathways. And therefore, wastewater utilities and farmers are managing downstream impacts and not generating these compounds. So one thing I would encourage is probably not in this bill, but when thinking about legislative actions related to PFAS is source control. And I do know there was a good bill passed last year that did focus on PFAS inputs from industry. If that could be continued, the easiest way, I think, to stop the contamination is to shut it off at the source so that the PFAS is not making its way to wastewater treatment plants and then biosolids and then agriculture. HB 1275 provides liability protections for agricultural operations, but not for wastewater utilities. That is something we also urge you to think about in the future. I know on the federal level that is something that they are working on because wastewater treatment facilities are truly passive receivers of PFAS. We support the science-based PFAS standards for biosolids. We do urge caution on the timeline and to allow sufficient time for treatment development and infrastructure planning. Currently, there is no good technology to mitigate PFAS once you get to the wastewater treatment facility. Those upgrades are very expensive and technology is still evolving. So there is an potential implication of this bill, depending on what DES ends up setting as the standards, that it may be a de facto ban on land application if the standards come back low enough. And implementation of that should allow a phased approach so that wastewater treatment facilities can plan for where their biosolids are going. Because in New England, landfill space is, shrinking and shrinking, and the cost is rising and rising. And ultimately, if there is no funding outside provided to the wastewater utilities, that cost ends up getting passed on to the ratepayers. And it is. These utilities, and you have probably heard, operate under really tight budgets and a lot of regulatory requirements. So reducing land application as a management option without affordable alternatives would result in increased disposal costs, strain on existing treatment infrastructure, and could create financial stress. And it's not just wastewater treatment facilities. Nearly 16 million gallons of septage from residences that aren't directly hooked up to a wastewater treatment facility in New Hampshire go to wastewater treatment plants that beneficially reuse their biosolids. So as a predominantly rural state with widespread reliance on septic systems, New Hampshire really depends on these treatment facilities to safely manage every single flush. The last thing I just want to caution as we talk about agricultural liability, I do think the immunity is important to encourage soil sampling because without that, it will be hard to get farmers on board, and they may just stop accepting biosolids altogether. That being said, I do think when DES is considering the rulemaking around soil sampling that we do need to take into account those background levels that have been found in soils throughout New England, so that every site is not, inconsequentially kicked out of the land application program just because of background levels from other soil practices or rain or air deposition or anything like that. But I do think this bill represents an important step in addressing PFAS in New Hampshire, and we do generally support the bill, but with further refinement, it could be even better, and it can help achieve the goals of maintaining essential wastewater services, protecting ratepayers, and preserving sustainable biosolids management practices.
All right,
So-
April, you got opposed on here, so I'm going to put support. Right?
Oh, yes.
Okay.
Yep, sorry.
Just for the record, so nobody chews you out.
Thank you.
Right. You don't want anybody getting chewed out here. All right, questions from the committee? Seeing none, thank you
All right,
very
thank
much. Mr. DS Department. Yeah. Beautiful.
Good morning, everyone. Thank you for having us. For the record, my name is Ren Bowden. I'm the Residuals Management Section Supervisor for New Hampshire DS and the Wastewater Bureau.
Good morning. For the record, my name is Jeff Martz. I'm the Administrator of the Hazardous Waste Remediation Bureau.
Welcome.
Thank you very much. So just, we know time is fairly brief, so we just want to talk to the sections at which we would have rule over, and that's the rulemaking standards for PFAS. So our program in the Wastewater Bureau, we administer EMV, the Water Quality Rule 800, which is our sludge management rule. So that is the rule that sets what the requirements are that anybody that has what we call an SQC, which is a certificate of sludge quality that is able to meet the standards of our rule to be able to land apply. So we just updated this rule, just passed JLCAR on Friday, the new the effective date, which is going to add a whole bunch of the requirements for PFAS testing is going to be effective mid-May. And we've already been testing sludge for our SQCs for about 8 years. So when PFAS kind of came on the scene about 10 years ago in wastewater, we started to say, okay, let's find out what's out there. What does this look like? So we have about 8 years of actual data that we've been using, which ties into the current project that we're working on. So as was what was stated by some other people, we are working on a current modeling project to look at what the leaching pathways of sludge that is land applied on farms to see how much PFAS is leaching to groundwater, and we're comparing that to our ambient groundwater quality standards. So that project is currently going on. And one thing why it kind of took, a little bit of time to get here is because there wasn't a validated lab method to really test PFAS in sludge until the end of 2024. So EPA and lots of labs are working through many standards prior, many different ways to look at methods. Sludge is a very complex matrix, as you can think about. what's in it. It's really hard to really test and get really accurate data from. So December 2024, the EPA finally validated what's called the 1633A method. So that is what we put in our current rule as that standard to actually test, to have a pretty good verifiable level of what's in sludge. That prompted us to reach out for a vendor to contract this leaching modeling study, which we're currently doing, which we vetted at the end of 2024. That project started about mid-2025, and we're estimated to have that study done currently by October of this year, which will then lean into our rulemaking process once again to open up the 800 rules to set what those standards would be for the actual biosolids. Again, being as mindful as possible of those ambient groundwater quality standards, not just the New Hampshire standards, but we're also looking at those slightly lower standards from the EPA. So we're looking at against all of them, and it's important to note that what we're looking at here is every state has different soils, right? So we're looking at the northeastern soils, we're looking at the application rates that we use in our state, looking at the actual loading which we have in our state, so we can be as accurate as possible when those standards are set to safeguard as much as possible those ambient groundwater quality standards.
Questions from the committee? Senator Waters.
Thanks for the explanation of the timelines. This is what I wondered about in the bill on line 16, that you don't start your rulemaking until June 30th, 2027?
So that's what was kind of built into the current text as kind of our latest date. And by current text, I mean that the text that passed the House. We're pretty comfortable that we were planning to reopen our rules to start that process by the 1st of next year anyways, once the final report was done. So even though we're estimated to be done by October of this year, we know sometimes those times shift. So we're pretty confident by the end of the year, we're going to have what those standards may look like, so we can then start that rulemaking process by next year, if that makes sense.
Yeah, so if you're ready to go on January 1st, you would go.
Correct, yes.
So therefore, do you think that there could be adjustment on line 20? Because then it's not until January 1st, 2028 that you would have the authority to apply those rules. So I'm just, there we are. It's a year and a half, more than a year and a half out.
Yeah, so, based on how long the rulemaking process lasts for that, so if we get the report done by the end of this year, 2026, we reopen the rules 2027, we'll have the rulemaking started. It may take a good chunk of that year to go through every step to finally get the effective date for that rule. Could that be maybe too soon or too late based on how that rulemaking process goes? I can't really say. I'm pretty confident that at least we'll have what those standards look like. I don't know the timing of how long that rulemaking is going to take.
Would you be uncomfortable with changing the word beginning to no later than?
I think we could confidently meet that date.
I mean, in one way it says beginning of November, January 1st, but if you were done before then, you wouldn't be able to start applying those rules until January 1st unless it said no later than. See what I'm getting
Yes,
at?
correct. Yes.
Senator McConkey. Thank you, Mr. Chairman. Gentlemen, I don't know if you're the right person to ask this question, but I'll go there. Having some basic knowledge on water testing, small systems and so forth, it's easy to understand how I'm testing and taking samples for PFAS for water. And my understanding is, at least at the times I've had to do it, our state lab doesn't have that quality or method, so it goes to another lab. I understand how it can be easy to check for PFAS in sludge. It's still somewhat of a liquid at that state. But I'm confused how you're going to sample soil. And I'm assuming you're only in the plow layer, and if it's a large field, is there any thought process on how many samples and where would those samples go to?
Yeah, that's an excellent question. So the thought process is, prior to a permit being issued at a site where land application can happen, there's already soil testing, which is done just for the normal loading levels, right, which are in the soil prior to make sure we don't exceed any nitrogen, those aspects. Very similarly would be when we institute the PFAS standards, there would be a soil test when prior to that permit being issued, so we know what the initial state is on that farm. And I would, you know, and that's something we have to vet out is how we want to grid it out. So in a lagoon system, let's say, for like wastewater, what we do is we map out the like spreadable area or how much area is present, and we put that into grids so we can take it, you know, samples at various points throughout this grid to get a like representative sample of what's present. To look at those layers, we'd have to see again how far depth that the organic layer is. We know a lot of those PFAS compounds are going to bind to those that richer layers, and so our current modeling study is going to kind of tell us what those things look like, so then we can vet out what that sampling process will actually look like when we get to that stage. If that answers the question.
That's very helpful. Tell me about the cost factor for that.
Yeah, so currently ranging, at least for our cost, a soil sample or a sludge sample for PFAS using that 1633A method is running about $400 per sample. You know, as things go on, sometimes those shift over time. It's gotten a little bit cheaper, you know, since when it first started. I don't know how that cost is going to come over the years, but currently we're at about that price point.
And if I just to follow up,
Yep.
so 100 acre, 10 acre, how many samples over 10 acres would you need to take soil samples?
Yeah, so again, if we grid it out into a composite sample, you know, we would again take X amount of samples based on size. We'd mix all that into one sample, and that would just be a single sample for that one site permit, which is going to average it over that composite field. Again, if it's too large, we may break that up into sections. A lot of our sites are pretty small acreage. We don't have any huge sites. We only got about 40, a little over 40 sites currently, which have a permit. None of them are super large farms. So we'd have to look at those sizings, see what would give us a good representation of what would be in that field.
But you're thinking somewhere under $1,000 to do that soil?
On average, that's pretty much what we have talked about in the office, correct?
Thank you.
All right, one more follow-up, and then I'm gonna move on.
We had reference earlier from Representative Germana that he had shared with you his amendment. Do you want to comment on it?
Yeah, he did show us briefly this morning. Once again, it's really just looking at those dates for like rulemaking that pertains to us. Again, we'd be fairly confident with those dates. Again, it's a shift if we want to do it, you know, if we're done prior and have that date prior, that's perfectly fine. Again, our rulemaking study is really just looking at that PFAS, you know, in the soil, in the sludge, and making sure it's really safeguarding those groundwater quality standards.
I think what I'm referencing in Germana's amendment is the civil liability part.
Yeah, you know, again, that's something I don't think I'd be comfortable to comment on because that doesn't fall into our wheelhouse. And to your earlier point, we don't know what's been done on sites previously. It's hard.
All right, thank you, gentlemen.
Thank you very much.
Jason? And I have one more speaker after Jason, and then we're gonna have to close the hearing because we've got two more bills and we get kicked out at 12 o'clock. Make sure everybody gets treated fairly here.
Good morning, Chairman.
Jason, would you push your button, please? Thank you.
Good morning, Chair Avard and members of the committee. My name is Jason Randall, and I'm the Director of Operations for Plymouth Village Water and Sewer District in Plymouth, New Hampshire. I oversee a system that serves more than 1,100 service connections and manages wastewater and septage from over 100 communities across central and northern New Hampshire. In simple terms, my job is to return clean water safely to the Pemigewasset River and to generate biosolids for beneficial use that can be responsibly recycled and used as a nutrient-rich fertilizer on agricultural land. Every day, I'm responsible for protecting public health and the environment, and I share your concern about PFAS and its impact on agriculture, water quality, and public confidence. While I appreciate the House amended version of HB 1275, which moves away from the biosolids moratorium toward a more practical science-based rulemaking framework and controlled land application, I support the intent of the bill, but I oppose it as currently written. It is important to recognize that PFAS compounds are ubiquitous and are not created by wastewater utilities or farmers. The Agency for Toxic Substances and Disease Registry estimates that approximately 98% of the U.S. population has detectable levels of PFAS in their blood. These compounds enter the environment through multiple pathways, including atmospheric deposition via rainwater, at levels comparable to biosolids application. Locally, concentrations in Plymouth biosolids are often at or near what I consider background levels. In fact, PFAS mass loadings in biosolids can be extremely small, on the order of 1/3 the mass of a drop of water, which is roughly equivalent to 1 part per billion spread over an acre of land. Super small. These compounds stem from decades of widespread use in everyday products, many of which New Hampshire citizens may consume or use regularly. Of course, that's a personal choice. What I manage is the downstream result of what society collectively flushes and discards, including PFAS and many other emerging contaminants. Given that context, I want to acknowledge the role public perception plays in this issue. PFAS understandably raises strong concerns both locally and nationwide, but policy driven primarily by fear or the expectation of achieving zero PFAS is not practical with current science and technology. Setting that expectation can create unnecessary urgency that outpaces the science, leads to rushed decisions, and shifts focus from achievable, risk-based solutions. A more effective approach is to prioritize reducing exposure where it matters most, such as what DES has already addressed in Merrimack and Pease. With that in mind, I have concerns about several of the provisions of the bill and how they might play out in practice. First, the bill provides liability protections for only farmers. I don't believe that's equitable. Wastewater utilities, like farmers, are passive receivers of PFAS. Limiting protections to one group doesn't eliminate liability or risk, it shifts it. I would urge the committee to consider a more balanced framework that extends comparable protections to municipalities, wastewater utilities, and biosolids managers operating in compliance with state and federal regulations. Second, while I support DES developing concentration-based soil and biosolids standards, the timeline is too aggressive. Developing sound science, validating testing methods, and effective treatment technologies, the necessary infrastructure, planning, and funding all take time. Without that, we risk making land application impractical, not because it's unsafe, but because compliance becomes unachievable. That outcome would likely shift biosolids to New Hampshire landfills where capacity is already constrained and long-term environmental trade-offs are significant. Third, the soil testing requirements will add cost and complexity. That can be managed, but only with clear science-based guidance. PFAS is already ubiquitous in the environment from multiple sources, and unlike natural background conditions, distinguishing between historical human-caused background and more recent human-caused PFAS contributions is highly complex. It requires consistent sampling methods, reliable baseline data, and careful interpretation of the results, all of which are still evolving. Without that clarity, it would be difficult to attribute sources accurately or make fair risk-based decisions. From my perspective, a workable path forward includes a few key elements: equitable liability protections across similarly suited parties, timelines aligned with science, technology, and implementation realities, and funding support for municipalities, water utilities, and infrastructure needs. Stronger source control to reduce PFAS at its origin, clear and coordinated regulations based on what we can reliably measure and with data informed by the state background levels, native soils and groundwater. With that, I'm committed to working with the committee and stakeholders to develop practical science-based solutions. I appreciate your time.
Jason, thank you very much for your testimony. I got one question. So you work with water treatment, correct?
Water and wastewater.
And so
Yeah.
when you treated the water, how much of the PFAS can you get out of the water before it goes into the Pemmican-Wasset?
We do not currently have the ability to treat wastewater for PFAS. Neither does any facility within the state at this point in time.
Does that go into the Merrimack at some point?
It does, Pemmican-Wasset does discharge into the Merrimack, yep.
And does Nashua draw from the Merrimack River for its water supply? I believe so.
Yep.
I think that our drinking water is tested and remediated.
Right, can it be fully remediated?
In drinking water, there's technologies that have been implemented to treat for PFAS compounds. That also creates a sludge that needs to get disposed of through a carbon source.
Which is black, right?
Right. So here's our circular economy coming back around. So most of that gets landfilled or brought back to a wastewater facility.
So when you're downstream, it just keeps adding up more and more, correct?
Right.
Poor people in Lowell, if they're drinking that water, that's a drag. Gotcha. All right, that's all I wanted to know. Thank you very much,
Yep,
Jason.
not a problem.
Our final speaker.
Have a great day.
Yes, appreciate your testimony. Sheila? Did I say that right?
You did.
All right.
I know it spelled a little funny, but that's the Gaelic in you.
Well.
I had nothing to do
Sheila,
with it.
of course. Hi.
Don't get us going.
Yeah. Well, I've got a bit of Scott in me now. Just a little.
So for the record, yes, I am Sheila Connolly, and I appreciate the opportunity to sit before you today. I have been sitting before this committee for over 30 years on agricultural topics. And
I'm listening.
it's okay. But we are in my company, Resource Management Inc., are in the business of recycling residuals. We handle the wood ash or the fertilizer for farm fields. We also handle food waste, and we work with paper mills, and we work with many municipalities in New Hampshire to recycle their biosolids, including Nashua and Manchester and Dover and Durham. We are very in Plymouth. We're very proud of our program, and we've been doing this for a long time. I think that a piece of the story here is that New Hampshire has very extensive regulations already in place for this material. It's been in place since 1985 when we sat before you and had the emergency rules entered because there was sludge dumping going on from a firm in New Jersey, and they were bringing it up to the North Country and getting rid of it. So these are not unfounded ideas. However, as a result of that, Senator Jim Rubens was behind getting very exhaustive rules adopted here in New Hampshire. And we've had a great program ever since. So I don't know that this is a broken program or there's a problem in need of a solution. DES is marching forward with regulations that will address the concerns about soil and leaching to groundwater. And I think they're doing a great job. They fortunately did not react with panic like Maine did when this issue came up 10 years ago. Maine has since had to reinvent itself. Its costs have quadrupled for handling the daily flush. New Hampshire is taking a very thoughtful way to get through this and to understand it. 10 years ago, we didn't have data to tell you, is it okay? And I had to sit in the same seat and say, I think it is. At that time, there were only 3 labs in North America who could do the analysis. Now there are hundreds of labs. The price has come down considerably, so we're moving forward. And I think that the sky is not falling. I would ask for, and I also have to say, I don't even know which amendment you're talking about because 3 were introduced today. So I haven't even seen the words. But what I can say is I think that we need to trust the process that DES is going through to set standards that are protective of human health and the environment and not rush to judgment. And I would say, based on all the kind of questions and things, it might be a great thing to initiate a committee that looks at the daily flush and what should New Hampshire do? Because this is solid waste. This is, you all use a toilet today. Where do you think it's going? I can tell you the city of Concord, they were very concerned about this whole chasing for lawsuits, and they took their program of land application here in Concord for over 20 years and shut it down. Mm-hmm. They now ship every flush from this building to Canada. That is wrong.
It just comes downstream.
No, listen, the water, I also work with the water guys and they do a great job. The water is safe to drink, don't worry. And it's so, I am a little concerned about a rush to fix something that I think the process is moving forward to do this just fine. And if you say we can't spread anymore, well, guess what, Nashua? You will be quadrupling your costs.
Senator Pearl with a question, and we're going to end it with that if we can, please.
Sure.
Thank you, Mr. Chair. Gosh, and now there's pressure on me to make it a good question. Thanks for taking my question. Does RMI currently test the sludge and wood ash and things that they bring to the farms for PFAS?
Yes, so we test all the residuals that we manage.
Test results are provided to
DES.
Yes.
Yep.
Secondly, do you offer soil testing to the farms that you deliver to?
So we soil test every site that we go to. It's required as part of the rules and the framework that we operate in. We have not been testing for PFAS for every site because there were no standards on how to test it. So now that they're working toward that. That said, we have been in a voluntary research program with the University of Arizona, and we have tested the farm soil, that state-owned White Farm, as part of that national research. And it's not high. It's just not an issue. But
And that land has had application for a lot of years on it,
oh yeah, 30 years.
at least.
Yeah.
One more follow-up. If the presence or higher than, I mean, you do this with phosphorus already. If
Oh
there's
yeah.
incredibly high levels, recommendations are made. Would the same protocol be followed with PFAS?
Yes, so it would be based on the concentration found in the product and then what that soil's capacity is for managing it and the crop uptake. And you know, the other thing about that is somebody brought it up, all the farm sources, I mean, PFAS is in fertilizer, commercial fertilizer that you're buying to put on your flower bed this spring. So this is not special to just biosolids. And that field on 93, that was a septic site.
Yes.
Not biosolids.
That was residential.
That's not the same thing?
No,
Okay.
Oh.
it was residential. It was
Deflated.
residential septic.
Oh,
It's
is it
not
really?
coming out of commercial
Oh
plants.
dear.
Yeah.
Mm.
But I think they stopped that, didn't they?
They've moved it. Yeah. It's well run. It's a great program. Great hay.
They treat with hydrated
The
lime.
river's right next to it.
It's a setback is followed.
Yeah.
It's a good program. It really is.
Thank
Okay.
you.
Thank you.
Thank you all.
And with that, we're going to close the hearing, and we'll hear from the prime sponsor, 1128. We're going to limit it to 3 minutes for every person after which, because we got another bill to hear after this. You're in charge. I'll be right back.
Nope.
We got to do something about energy conservation.
Right. Representative Potenza, are you introducing? I'm just making sure I'm reading this right. Oh, okay. Come on up. We're going to open the hearing on House Bill 1128. Okay. Good morning and welcome. Whenever you're ready, the floor is yours.
Thank you, Mr. Chair, members of the committee. For the record, my name is Representative Kelly Potenza, Stratford District 19. I'm here today to introduce House Bill 1128. House Bill 1128 is a narrowly tailored, constitutionally grounded bill. It does not ban weather modification. Instead, it establishes clear guardrails to ensure that any of these technologies in New Hampshire occurs only during true emergencies with transparency, accountability, and most importantly, public consent. I passed out my testimony. If you want to go to the last page of it, this is what is, this has been going on this is the 4th year that we've tried to get this through, and now we have it. So it actually left ST&E on the House side on consent, which was great. So it flew through the House, and everybody got on board with the language. So it's basically repealing this this bill or this law from 1985 that allows New Hampshire citizens to be, in a sense, weather modification experimented on. And then it basically replaces it with 1128. So I just wanted you to see this section 12F that's the first part of the bill. It's going to be repealed. So, basically the constitutional foundation for the bill is its consent of the governed. So The New Hampshire Constitution is really explicit. All political power is inherent in the people and founded in their consent. Weather modification is not a localized or private action. It's a statewide intervention into shared natural systems affecting, of course, air, water, agricultural ecosystems, and private property. When the government alters the atmosphere, it is acting directly upon the people in their property. And that action, of course, requires consent. So Y12F needs to be replaced with what is being put in there. So the current law explicitly authorized the state to engage in, quotes, experimentation in the techniques and methods for weather modification. That's really the problem. The statute does not limit activity to emergencies. It does not require meaningful consent. And most importantly, it explicitly authorizes experimentation on the environment and by extension, the people of New Hampshire. So while RSA 12F includes notice provisions, the notice is not consent. Publishing a notice in the newspaper is not the same as obtaining the informed consent of the governed. There's no mechanism in the statute for meaningful public approval, opt-out, or representation of impacted communities before experimentation occurs. The citizens of New Hampshire have never consented to being subjects of atmospheric experimentation. And then, of course, under Part 1, Article 2, individuals have a natural right to life, liberty, and property. Also under Article 1, government derives its authority from consent. So a state that authorized experimentation affecting all three without consent is really constitutionally suspect. There was talk when this first was put in that we were just going to repeal 12F. And if you look, you can see some several co-sponsors on the bill. And if you look at 12F in general, my chairwoman, Judy Aaron, she specifically had put in some of those safeguards for notifications in there. And she wanted, of course, this to be able to have, of course, in a severe drought situation, if the state ever decided to do any sort of cloud seeding, she wanted that in there. And so that is the reason why we came to this further amended version, which, like I said, was, there's two members, I believe, three members of the House Science and Technology Committee as well that approved this as well. So that's kind of where we're at. I don't have to read the rest. It's pretty self-explanatory. So the HB 1128 fixes basically the deficit in what 12F had. So it replaces the framework with weather modification is restricted to extreme or exceptional drought conditions lasting at least 90 days. It requires environmental review and DES oversight. And by the way, this language was worked on, and he's here, which is wonderful. I think he's still here, with DES as well from the first iteration. So that was really good to have. And of course, it mandates advanced public notice and full disclosure, which is really the most important part of what chemicals or technologies that are going to be used in whatever they're using in the environment or in the atmosphere. And also it creates post-activity reporting, which is directly to the governor and the legislature. I do want to say, just because I did a lot of research on this, the department had no knowledge ever of there being any cloud seeding in New Hampshire. And a homeschool family found in a very old book that talked about New Hampshire history that in 1950 there was cloud seeding that was done one time. So I can send you that if you wanted to know. But I found out something that the department didn't even know. So that was kind of cool. And so I will just end with basically this authorizes, my final points are 12F needs to be repealed because it authorizes experimentation without consent. That's incompatible with the Constitution foundation of the state. Instead, now we've got 1128 replaces it with emergency use only, clear safeguards, and public accountability. That's not anti-science, and it's constitutional governance. So I'm hoping that you can support HB 1128. And that's pretty much it, if you have any questions.
Well, you answered the one question I had, which was going to be, has it ever been done in the state? But you already answered that. So Senator Waters.
Thank you, Mr. Chairman. So I understand the logic of this and consent and so on. It's all good. My question had to do around with the original statute, the existing statute.
Mhm.
Because the bill now just is cloud seeding,
Correct.
whereas the original statute might conceivably cover other kinds of experimentation. So wouldn't the effect of passing this be that we would have no regulation on other kinds of experimentation?
I I guess, but it's kind of interesting because how the process worked was that if somebody wants to perform any sort of experimentation, that they would have to go to the governor and council and all of that kind of stuff. Now, I believe that if there's an entity, if it's the federal government, let's say, because most of this stuff is happening through any sort of weather experimentation, which is called SAI and SRI, stratospheric aerosol injection, or stratospheric radiation injection, is basically that's all done through NGOs, through NOAA, through all of that kind of stuff. They would have to, I would assume, it would work the same way, but it would go through like the Department of Environmental Services. So if the federal government wanted to do something here in the state to do weather experimentation, it should go to the executive agency that handles that. So not going to the governor and a council.
I wasn't so much interested in the federal government, but I'm just saying that, what you're describing in the replacement is a program to do cloud seeding to essentially treat drought or whatever. The original statute, experimentation and techniques and methods is not the same thing as trying to do cloud seeding to modify the weather. So there might be some experimentations on certain things that now would be unregulated by the state. And I also was wondering too, is there's no way this would affect snowmaking for ski areas?
No, they don't
I'm
use.
sure about that.
Correct.
Okay,
Yeah.
sorry. I mean, that's why, I think I understand, and I kind of support what you're saying in the bill, but I'm just worried about repealing any state authority over experimentation. That might be other things that we haven't even imagined yet, or might deal with, reflectology and other things that people are looking at and thinking about. So anyways,
because
that's what I was getting at, is that now we will no longer have any state authority over any experiments that might be done here.
But there hasn't been. That's what I'm trying to say, is there's never, if these experiments that are happening are not happening on a state level at all. So they're happening on the federal level. And those things they're not ever gaining consent right now. So this law that's been in place that basically says, since 1985 has never been done. No one's ever gone to the council. Like, that's what I'm saying, that this whole piece here is, it's here, but it's saying, hey, that there's a process, but it's not being done either. So, and the only piece that I know of really, in regards with, I get what you're saying. It's only covering cloud seeding because that's the only thing that we know of that is happening. For example, in Utah right now, they are, the government is using cloud seeding to try to fill a lake that is, that has been one of the Great Lakes, or their great, I don't know if it's the Great Salt Lake or whatever, that has been pretty much emptied. So there's a lot of, I can give you tons of that information if you like. Now that would be like in this sense, it's a contract. They have a contract with the state. They work with their Department of Environmental Services. That's all public. That's all by consent. That's what I'm saying. Like this, how it's written is just doesn't really make any sense because it's never even been used. The Executive Council, when I had no idea that this was even in place.
All right. Thank you, Representative. Any further questions? Senator Rosenwald?
Thank you. It's a similar question to Senator Waters, because my first term in the Senate, I was on EDNA and we had a bill similar. Well, it was broader. It prevented weather experimentation, but Because my question is, since the federal government may be doing these kinds of modifications and clouds move, could we really affect protection over our landmass by passing this if they were going to seed clouds in Maine or Vermont and the wind blew them here?
No, I mean, actually, if you talk to the company that does cloud seeding, which came out here, I'm not sure if you've heard there's a lot of hoopla about them. They're called Rainmaker. They came, the gentleman that came, I believe, was from Texas. There was a lot of talk about the cloud seeding that was done by Rainmaker, there's naysayers that say it caused the floods, those big floods that were in Texas that had incredible amounts of damage and death. So they say that it's very pinpointed. So because it's not something that is just done in a fashion where there has to be certain conditions when it happens. You explain the science behind it, which I'm not an expert on. But no, this is basically just saying if we were in a situation where that we needed cloud seeding for extreme drought, that through DES that there would be a pathway for that. I mean, if we were to put in, this isn't a ban because we're removing 12F. There's, like I said, this is the 4th year on this now. So there was talk at first about banning weather modification completely. And I'd be for that, but there wasn't an appetite for that. So because of that reason, this is where this compromise came in. And I do understand what you're saying, but this is just what we can control in the state. When it comes to the federal stuff, and if a state is contracting with cloud seeding or doing certain types of techniques to help their environment or whatever it may be, that's different. But if you're talking about weather modification, stuff that's happening on the federal level, there is no state, even though Florida passed a complete ban on all of their weather modification stuff. You can't police the skies. That's really, it's the hardest thing. This would have to be done on the federal level. There are 2 bills right now in the federal government dealing with weather modification, geoengineering stuff. But for the most part, this is the one thing that we can do to control, because we're not going to be able to do anything else, really.
Thank you, Representative. One real quick one. I got to move us along. I'm sorry.
Thank you. You don't have any timeline for how quickly DES would have to conduct a review or issue its findings. So couldn't they just allow it to go forward and say, well, we're not finished with our studying yet?
I guess so. Do you want to answer that question? Yeah, he could address that question. With this language was literally worked on directly with DES, and the gentleman that was in the previous position that worked directly with the governor's office. So this was what came out from it, and the department was okay with it, as well as all the different co-sponsors on it. So
thank you.
Thank you. All right, thank you, Representative. Representative Aaron? Marquette School Group.
Thank you. And for the record, Representative Judy Aaron, representing Sullivan County District 4, the towns of Ackworth, Goshen, Langdon, Leominster, and Washington. And I appreciate you calling me to testify on this bill this morning. I just wanted to give a little bit of background because I was the one who updated this law back in 2021. I put in, originally had put in a bill to delete the entire RSA and came before Senator Carson's committee at the time for what I guess it was Executive Departments and Administration. And sort of through that, the whole testimony came out, said that wasn't a real good idea because then you have there's no word of that in statute. Now, just as historically, back in the 50s, they did a lot of experimentation up in Mount Washington, having to do with cloud seeding, having to do with new technologies, because New Hampshire was having difficulties with drought, and it was affecting snow and commerce at our ski areas. I did a lot of back research on when this RSA 12F:1 came into existence to begin with. And what I had added back in 2020, after that first go around with Senator Carson's committee, was instead of eliminating the entire statute, was at least to put a notification piece in there to let the public know what kind of experimentation might be taking place. I had polled every single agency, DES, the Health and Human Services, entire departments, to ask them if they had ever gotten a request from the federal government or worked with DES with regard to any kind of weather modification programs. They all replied no. The only things that they had ever been aware of was back in the 50s when they were doing these kinds of atmospheric tests and experimentation with regard to drought and how to deal with drought. So since then, we are not aware of any kind of experimentation, although there have been reports from people of seeing, things up in the sky, becoming sick or ill from whatever was being sprayed. You cannot, whether you believe in weather modification or geoengineering or any of that, the fact of the matter is even though Florida has put in some, bans, there's no way that you could really control that other than, because how do you even report it? You see a plane, you don't know what the letters are on the side of the plane. You can't report that to your local sheriff or law enforcement or anything, because there's really nothing that you can specify to say that who is doing it, why they're doing it, or whatever. So the only thing that we could come up with for when I made the change was basically, if the state is working in conjunction with federal government or with other agencies in the state with regard to any kind of experimentation or atmospheric work, that they should have, that there should be some notification piece to what was already in statute. And that's kind of where that is right now. And I just see that for this, since there hasn't been any kind of programs other than cloud seeding, that's where sort of I came up with speaking with Representative Potenza about her bill. So I don't know if you have any other questions for me, regarding the history behind this or why, but, I think it does make some sense that, we can limit what the state is doing with regard to what their experiments that they're performing atmospherically to just the cloud seeding in case, we need something to be done with regard to solutions for drought conditions. Anything else, as to your point, Senator Waters, that sort of eliminates any other kinds of tests that could be useful. I don't know how you feel about that.
Further questions from the committee?
No.
Thank you, Representative.
Okay, sure, thank you.
Michael?
Mr. Chairman, the department doesn't take a position on the bill. I'm available for any questions.
Okay, we have one question if you're available.
I am available.
All right. We like your availability.
I'm here and available. I'm Michael Fitzgerald. I'm the Assistant Director of the Air Resources Division in the Department of Environmental Services.
And Senator Pearl has a question.
Thanks for coming up.
Sure.
So reading the bill, I don't know, do you have a copy of the bill in
I
front of you?
do.
Yeah, if you look on line 11, well, 10 and 11,
Yep.
it's charging the department with determining, you know, that the activity would result in harm to the environment, public health, or wildlife. What determination criteria would you use to fulfill that duty?
The only criteria would be that it's here in the statute. There's no rulemaking authority with this. So as I testified in the House, let me make clear that the department has no expertise on weather modification, cloud seeding, any of the topics of this bill currently. And as was mentioned previously, we did meet with Representative Potenza. The original bill had some pretty onerous requirements for environmental review to be conducted by the department, and declaration of emergencies by the governor, et cetera, and so on. So we were able to work to remove those and come up with language that we could live with, that would require the entity that proposes to do this to conduct an environmental study or an environmental review, but there are no criteria in here other than assessing potential health risks and benefits, and that review would be submitted to us. And if you note, the language doesn't say anything about the department approving. It says the department may reject. Bottom line, as I testified in the House, we do have a public health group that works on numerous topics, including the bill that you just previously heard, setting MCLs and providing science expertise on public health impacts. We would take whatever was submitted to us, we would give it to them. They would review it and give us some feedback as to whether they saw anything that was potentially significant that would rise to the level of the department saying, no, we don't recommend that this go forward. But that would be the extent. And again, we have no particular, this bill doesn't provide any resources, and we have no particular expertise in this arena.
Follow up?
So would it, I'm just trying to, would it make, is it necessary to put some definitions to these criteria in here? Would that to guide the department?
Well, I guess our feeling is that since cloud seeding hasn't occurred since 1950, the chances of this being enacted, and again, as both representatives mentioned, I don't think there's been any activity under the previous RSA 12F, although it's not specific to our department, it allows any department, but we're unaware of any activity, and that statute has been in effect since 1985, as best I can determine, or even possibly previous to that. I guess the question is, if this were to be presented to us, if someone wanted to do cloud seeding in New Hampshire, which hasn't occurred apparently since 1950, from the testimony that we heard previously, we would do our best to make an assessment and determine if there were any potential health effects or impacts that we thought should preclude that activity.
Thank you. I'm just always cautious about charging an agency or a department with doing something without giving them the guidelines.
Yeah, I mean, most times in situations like this, there'd be some rulemaking authority and so on. But again, we testified we have no resources to, and this bill doesn't provide any resources. I do have this public health group, but they're not just sitting there waiting to review cloud seeding studies. They have full-time jobs working on topics like PFAS and other emerging contaminants and environmental health threats in the state that we're dealing with currently.
Thank you.
Thank you.
Any further questions? Seeing none, thank you very much.
Thank you.
And I don't think I have anybody else here to speak, so we're gonna close the hearing and hear from our prime sponsor on HB 1577. Thank you, thank you. Whenever you're ready, Representative.
Thank you. Good morning. Thank you, Chairman, and thank you, Committee.
For the record, my name is Representative Margaret Dry. I serve Sullivan County District 7, which is Charlestown, Unity, Newport, Plainfield, and Cornish. And the bill you have before you today stems from a conversation that Senator Ward and I had with Eversource during a public meeting they had where we learned a little bit about how to help customers who might be having trouble with their utility bills. And an ancillary conversation there was about people on life support who can't have their power go out for very long or can't have it cut off. And as an EMT, something that interested me, and we talked about that list that they had, and we found out that there is no way for emergency personnel to access the list that the utility has. And I said, why not? And it's because it's not listed in the list of exemptions. Third parties can't get this information unless they're an exemption to that forbidding of giving out information of customers to third parties. So we worked on this bill, and it came up in the hearing that we needed to kind of pinpoint exactly who the information would be going to. And also people were concerned that perhaps a right to know request would divulge medical information or sensitive information about somebody. So we worked to correct those two things. We've got what you have is the original statute, the list of exemptions, and we added what I added as the emergency management director in a town, because it turns out that in RSA 21-P:39, every town or municipality has to have an emergency management director appointed by the town council or selectman as a point person. I thought that's a good hat to hang this on. Then we talked about how to make sure that it was kept private, and decided that personally, I think it's already medical information and it's kind of an exemption to the right to know. But to make sure that that's true, we added the section at the bottom that's a disclosure of this is exempt in 91A. So those were the two things that came up in the hearing that we talked about. In my personal experience as a rescue squad member, we've had times in the summer, we've had times in the winter when we've had extended outages. And the problem that we have is we're just working on our general knowledge pool of who might need to be checked on. There's no list. The fire department has some names, the police has some names, our welfare officer has some names, but there's no one place to go to look. And it's a list that changes all the time. People come home from the hospital with medical needs. Babies are born that might need supplemental oxygen for a time and then not be on it. So it's something that's fluid, but we didn't have anything. This bill intends to fix that disconnect. There is a nice list the utilities have. We can put it to use safely and privately, and now there would be a connection that we can make that.
So what's the trigger point for somebody to be checked on?
From the point of view of the utilities, they sign a life support document kind of with the utility knows that they're there.
What do they do?
It's just that they will not shut off their electricity.
Oh, they will not shut it off. Okay, but if there's a power outage, I'm thinking
There's power outage. That's where we step in,
Okay.
because we may have to take supplemental oxygen or clear it, make sure that these are the roads or the driveways that are cleared first.
Yeah.
Trees, I spent, in 2017, my husband and I spent most of a night in the early hours of the morning climbing through trees and bushes to get to someone's house that needed oxygen. But that's because we knew that they had that problem.
Yeah, I'm thinking like Nashville when we had that super freeze, and there was a lot of power outages.
The ice storm in New London took out our power for about a week in Plainfield.
Right, and so this basically helps individuals to.
Sure, if you have limited time and limited resources, you want to send it to the people that need it the most first.
I see.
And this would help do that.
Senator Rosenwald.
Thank you. So if I'm on oxygen, how does my utility know that?
That's between the person and the utility. You tell them.
I would have to tell them.
There's somebody here from the utility who will be able to go into that better for you.
Okay.
Okay.
I feel the Neil Kirk coming out of you.
Well, I'm pretty sure that Eversource is not a HIPAA entity.
Any further questions?
That's it. I'm just saying that the intent is to just do the best job we can, getting the resources to the people that need them the fastest.
Thank you. I see no further questions. Thank you very much, Representative.
Thank you.
Mr. Griffin. From Eversource. Ambivalent.
As always. Thank you, Mr. Chairman, members of the committee. Griffin Roberge, Manager of Government Affairs with Eversource Energy. Eversource is neutral on this bill. I did pass around an amendment that we think would offer some helpful clarifications to the bill. So first off, very much appreciate Representative Dry's intent with this bill. As she mentioned, we hosted a Let's Talk Energy event last fall, I believe in Newport, where we educate customers about their bill. There was a discussion with elected officials there about sharing sharing customers who are medically coded with municipal officials during times of major outages. As I think folks on this committee know, New Hampshire's state policies tend to be very heavily privacy oriented. There is a specific statute that prohibits utilities from sharing customer data with third parties with limited exceptions. This bill would expand one of the existing exemptions in that statute to allow utilities to share individual customer data, specifically medically coded individuals, with emergency management directors as it is described in the bill. Our amendment that I think you probably all just got, we are looking for a very minor clarification to that to align with Eversource's internal processes when it comes to working with municipalities. So kind of step back a little bit to kind of address a little bit of what Senator Rosenwald asked. What is a medically coded customer? Medically coded customer is a customer who contacts us and fills out a medical certification form that is signed off by their doctor indicating that the absence of electricity would be a detriment to that customer for medical reasons. Therefore, by completing that form, they are coded in our system as being prevented from being shut off from electric power in the instance, say, they fall into arrears on their electric bill. It does not place any type of higher priority in terms of the restoration of power. We obviously work through our process. During those times of emergencies, say storms, outages, we have an application called the Municipal Hub. That Municipal Hub, we work with with points of contact in each of the towns that we serve. The Municipal Hub is our main application that we use to funnel communications down to the municipal level about our restoration efforts. It is also a pathway for that point of contact at the municipal level to elevate important priorities for the community, whether it's, say, a school is out of power, they need a generator, there's a pole down on a road and there's a car trapped and they need the poles cleared. So these are the types of things that the Community Hub would be able to offer. What this bill would do was simply allow utilities to offer to identify those medically coded customers to municipal officials, as Representative Dry indicated. Our amendment would simply clarify that it would allow us to work with the municipalities' authorized public safety officials. The way that our current process works is that municipalities designate the individuals that they would like to be their points of contact for us in the event that storms occur. We feel that the current language in the bill with emergency management directors is an undefined term in statute, and we would like to preserve the municipality's flexibility to designate who they wish as their point of contact to work with us, and also, again, foster that flexibility that the municipalities currently have. We just don't want to see any confusion between who exactly we are working with at the municipal level in times of outages. So again, we feel our amendment is a very helpful clarification. It preserves the intent of Representative Dry's bill, and we certainly welcome this committee's consideration of that amendment.
So is this the same thing as it's amended from the House?
Yep. So if the amendment that I passed around is currently the language of 363:38 5B. And the amendment simply swaps out the bolded language in the bill that you're holding up there, Senator.
So with that, are there any further questions? Seeing none, thank you very much.
Thank you.
And I don't see Representative Judy Aaron in here. She's in support of the bill, but she didn't want to speak. So with that, we're going to close the hearing on this particular bill. And motion to move into exec, Senator Pearl, seconded by Senator Waters. All in favor? Aye. Any opposed? Seeing none. Is there a motion on 1577?
Move up the pass.
Second. Okay, discussion.
I'll move the amendment that we were provided by Griffin.
All right, and seconded by Senator Rosenwald. Discussion.
I will say this affected dramatically two of my family members. I'm going to pass this, and I know people who died during COVID because the electricity went out in their oxygen machine. So,
oh wow,
let's do it.
So let's make sure that we get the amendment right. Where's the changes? Okay, you got it?
Yep, it's just coordination, municipalities, authorized public safety officials, and then disclosure of customer data to municipalities, authorized public safety officials, shall be exempted.
We all good?
Yeah.
Of course, yes. So all in favor of the amendment?
Aye.
Any opposed?
Move up the pass as amended.
Second. Seconded by Senator Pearl. Discussion, all in favor of ought to pass as amended?
Aye. Aye.
Any opposed? Seeing none. Consent,
Second.
Senator, yes. Senator Rosenwald said consent. Senator Waters seconded it. We're all thirding it. So all in favor of consent?
Aye.
Any opposed? Seeing none. Who wants to take it out?
I'll do it.
Senator Waters is taking it out. Okay, there's one.
I have no problem with 1128. We had a hard talk about it, but I just don't see why it seems okay.
I think I want to think about that one a little bit.
All right, fine.
Are there any other bills on anybody's mind right now? Otherwise, we're going to have a huge.
I would say,
On 1275, I mean, again, we heard, I think that there may be other things we need to do later.
I do have an amendment for it.
And you have an amendment that we could do, which makes sense, but I think for right now, we ought to do what we have. It gets it started on protecting the farmers, and if we need to address other areas later on, we can, but this, and they'll get the rulemaking going.
so I'll move 1275 ought to pass.
Second,
Second, and
I want
then
to offer an amendment.
you have an amendment,
all in
sir.
favor of that?
Well, no, you're going to add your
You
amendment.
got your amendment.
Yeah. Well,
This is, Kevin has an amendment.
I have an amendment.
All right, so what amendment are you offering?
I am offering amendment 2026-1449. And the amendment, thank you, and discussion. So
Yeah,
this,
I can, well, go ahead.
yeah, this is relative
I see the
to
logic of it.
the
Yeah.
PFAS substance, exempting certain PFAS. This really has to do with the United States Department of Defense and International Traffic and Arms Regulations, 22 CFR, which is parts 120 to 130, or the Export Administration Regulations. And so basically, we're in a time right now where we have industries in New Hampshire that really require this amendment in order to continue supporting our war effort, if you will. And so this basically supports them. I don't know if you had
Yeah,
comments.
and I'll just say that this, what you've done here with this is add this exemption to a list of other exemptions that are in statute, and it makes perfect sense. When you look at that list, this be added to it. And let me add as well that people may not know that we have actually a free trade zone in New Hampshire over at Pease. And this is the kind of thing that the people who want to be able to transport things through there. So I don't know if this affects that in particular, but I think it makes perfect sense for the national defense purposes you outlined.
Further discussion? All right, all in favor of amendment 1449S?
Aye.
Any opposed?
And I will say on the underlying, I'll move ought to pass as amended.
Second by Senator Pearl.
And I'll say on the
By
underlying
Waters.
bill, I appreciate Representative Germano's amendment, but I don't really feel it's necessary. I think the underlying bill and the current definition of agriculture very much addresses the concern, and I'm happy to support the bill as amended.
Further discussion? All in favor of ought to pass as amended?
Aye.
Any opposed? Seeing none. Is there a motion for consent?
Yeah.
All right. All in favor of consent?
Aye.
Any opposed? I guess I'll take this one out. 4-0. Consent Avard.
The other bills we heard today, probably we need a little bit of
We
time.
did 1140, by the way, Mr. Chairman.
Yes, we
Yeah,
did.
I heard. Yeah, thank you. Good job.
That was an easy one.
We passed it.
Is there any other bill on your radar that you would like to do for right now?
What's our list?
Well, we have. This one. We already did that one. Okay.
Yeah, got it.
We can hold some until next week if you want.
I think we ought to, just because as with the issue I mentioned earlier,
Yep.
why don't we just hold and see what's happening in the other body?
Brother Pearl?
I'm fine with that. So, but we could meet next Tuesday, and they're not acting until, are they acting tomorrow?
This Thursday,
got
yes,
it.
so that will clear us
Yep.
out for Thursday, for
Okay.
next Tuesday potentially, do what we want to do.
Senator Rosenwald, you okay with that? Yeah. Okay.
Motion to come out of exec?
Seconded by Senator Avard. All in favor?
Aye.
Any opposed? Seeing none, we are dismissed. Gracias. Thank you, everybody. Yeah, so we'll wait.
Howard. David.